Hello. So I'm back here now with the Abel opposition to Jonesworks motion for spoliation sanctions. I'm expecting this to be largely the same as the lively opposition from Wayfarer. What I'm going to do, I think, just to try to keep the video to as short as possible, is I'm not going to read the legal standing because we've already been over that in the lively opposition. So I'm going to just go through the kind of the facts and the arguments, and then cut out most of the legal standard and case citations, I think. I did try to do that in the other video as well, but there are things like it's important to understand how it all works and what the standard is and what the tests there are. So I did read more of it in the last video. The standard is going to be the same. She's asking for pretty much the same thing. So I'm just going to focus more on the difference between, in the arguments, because they are different cases, different plaintiff and defendant. So they had a different relationship. Okay. So introduction. Stephanie Jones and Jonesworks, collectively Jones, Sanctions motion is odd indeed. Now, I haven't read this one up front. I glossed over the lively one before I recorded. I have not read this one, and I'm already loving it. Right. Stephanie Jones and Jonesworks, collectively Jones's sanctions motions is odd indeed, lacking any serious attempt to justify sanctions for spoliation of electronically stored information under Federal Rule of Civil Procedure 37E. Jones falls short of meeting even the threshold requirement for application of Rule 37E, namely that at the time signal messages were allegedly deleted, and since November 2023, Jennifer Abel anticipated litigation concerning her August 2024 public relations activities on behalf of her clients, Wayfarer Studios and Justin Baldoni. The subject matter of the allegedly deleted signal messages and chats, and thus had a duty to preserve the communications, assuming they ever existed. This is going to be fun, I think. Jones merely cites evidence that Abel anticipated litigation against Baldoni, Jamie Heath, Steve Sauritz, Wayfarer Studios, and It Ends With Us movie. Collectively, the Wayfarer defendants or Wayfarer parties, relating to Blake Lively's allegations that she was uncomfortable on the set of the film It Ends With Us, which occurred over a year earlier, between May 15th and June 9th, 2023. Simply put, evidence Jones contends was spoliated would have been relevant to the August 2024 public relations strategy, not the alleged harassment claims that were subject of the only foreseeable litigation. Jones makes no effort to explain if or why Abel would contemplate litigation in November 2023 over a public relations campaign that allegedly launched in August 2024. Jones's motion similarly fails to pinpoint a particular message or chain relevant to Abel's indemnification claim, which Abel deleted, or even whether Abel was a participant in any pre-litigation signal thread concerning Lively. Cognizant of the shortcomings in her motion, Jones merely urges the court to presume that Abel participated in signal chats about Lively, the unspecified, indeed mythical, signal messages were relevant to Abel's indemnification claim, and their deletion prejudiced Jones. Oh God, I've got tears. I'm almost crying with tears, like laughter. However, Jones fails to show that Abel, who could not possibly foresee litigation involving her public relations work, acted in bad faith, the requisite showing for a presumption of relevance and prejudice. Nevertheless, based on this very shaky house of cards, which requires the court to stack presumption on top of presumption. Oh, this is so good. Jones seeks the most severe sanctions available under Rule 37E2, including, at minimum, a sweeping adverse inference that allegedly destroyed signal messages would have been favourable to Jones. The broadly defined defendants conducted a digital or smear campaign against Lively without Jones's knowledge, involvement, or approval. Abel participated in that campaign for her own personal benefit, outside the course and scope of her employment with Jones, and Abel acted with the intent to deprive Jones of relevant information. When you read it all like that, it's wild. It's wild that she even filed that motion. Jones also seeks to preclude Abel from refuting these allegations at trial. The exceedingly broad adverse inference and preclusion order sought by Jones would be the death knell for Abel's indemnification claim. And that's what she wants, because Abel's got a very strong indemnification claim against her. Sorry. As elaborated below, Jones falls woefully short of meeting the harsh standard for sanctions under Rule 37E2, or even the lesser sanctions available under Rule 37E1, and thus her motion should be denied. 2. Factual background. A. The employment relationship between Jones and Abel. Until approximately August 2024, Jones was Wayfarer's public relations agent, and Abel was the Jonesworks employee primarily responsible for the Wayfarer account. On August 21st, 2023, Abel was terminated. She then opened her own public relations business. Prior to Abel's departure, Jones's chief of staff, accompanied by security and legal counsel, cornered Abel, seized her cell phone, and subsequently downloaded her text messages and emails, including her communications with Jones's client, Wayfarer. Jones subsequently delivered Abel's communications to Lively, redacted. Understanding that sharing the information purloined from Abel's phone carried risk, Jones and Lively created a ruse to give legal cover to Jones. On September 27, 2024, an entity known as Van Zandt, redacted, filed a sham breach of contract claim in New York Supreme Court. The complaint, brought by Doe plaintiffs against Doe defendants, did not describe or attach the allegedly breached contract and lacks any factual allegation. And then we have a bunch of depositions, declarations, etc., all redacted. Once Jones produced Abel's communications to Lively, Van Zandt dismissed its state court complaint. These facts leave no doubt that the Van Zandt complaint was filed for one reason only: to provide a mechanism for Jones to transfer the information stolen from Abel's phone to Lively. B. The facts giving rise to interlocking lawsuits in which Abel is a party. 1. The film and Lively's complaints about misconduct on the set. So let's have a look. The film began shooting, etc. Lively complained during phase 1. So this is stuff we have seen. I'll go through it anyway. The film began shooting in New Jersey on May 15, 2023. Phase 1 ended on June 14, 2023 due to Writers Guild and SAG strikes. During Phase 1, Lively complained about purported mistreatment by Justin Baldoni and Jamie Heath on the set, including alleged conduct that made her uncomfortable. Lively did not file a formal complaint, but voiced her concerns to Baldoni, Heath, and others, redacted, no later than June 1st, 2023. Abel, who was employed by Jones, was not involved in the production of the film or Lively's complaints of mistreatment. The protections and resolutions of Lively's complaint. So this is talking about the demands letter, November 9th, demands letter. During the strike-related pause in filming on November 9th, 2023, the Wayfarer parties received a letter from Lively's lawyer, Lindsay Strasberg, demanding that Wayfarer agree to a 17-point list of protections as a condition for Lively's return to complete the film. The letter stated that if production is unwilling to accept or uphold these protections, our client is prepared to pursue her full legal rights and remedies. On November 10th, 2023, Wayfarer forwarded Strasberg's demand letter to Abel in her capacity as Wayfarer's public relations consultant. Wayfarer agreed to the protections. Wayfarer understood that their agreement to the protections resolved the issues that had arisen during Phase 1 and eliminated the threat of potential litigation. Abel is not a party to the protections, and there is no evidence that she was involved in any way in Wayfarer's negotiations or decision to sign the protections. Filming resumed on January 5th following an extremely tense all-hands meeting on January 4th, 2024, in which Lively's husband, Ryan Reynolds, spent hours berating the Wayfarer defendants for their conduct in Phase 1. After returning to set, Lively did not assert any further complaints. Filming, which began on January 5th, wrapped up on February 9th, 2024. Like Phase 1, Abel was not involved in Phase 2. There is no evidence or even allegation that the Wayfarer parties failed to uphold the protections during Phase 2. Lively redacted. Abel did not attend the January 4th all-hands meeting and did not have any contact with Lively about her complaints of misconduct in Phase 1. 3. Lively's assault on the Wayfarer parties. During Phase 2, Lively moved to seize control of the production, among other things, redacted. Ultimately, Lively gained control over the entire post-production process, redacted. Lively also demanded that, redacted. Lively accomplished her takeover through threats that if her demands were not met, she would not participate in marketing the film, even though she was contractually obligated to do so. Not content with usurping Baldoni's role as director and excluding him from the marketing of the film, he developed, financed, directed, and starred in. Lively then sidelined, indeed banished Baldoni from the premiere, refusing to be photographed with him and demanding that he and his guests be hidden from sight and shunning Baldoni and his guests into another screening room. Baldoni was also barred from appearing with Lively in publicity photos or promotional appearances. Lively very publicly unfollowed Baldoni on social media and redacted. Four, the surging chatter over Discord on the film's set and the public relations response to Lively's attacks. By the time of the film's August 6, 2024 premiere, rumors of discord on the film set were already swirling on social media and in the press. These rumors were fueled by redacted. Lively's unfollowing of Baldoni on social media and Lively's insistence that Baldoni be stripped of the credit filmed by Justin Baldoni on the movie he developed, sold, directed, and starred in. And then there's a bunch of stuff redacted. This decision was particularly tone-deaf given the role of alcohol abuse in domestic violence cases. Nevertheless, Lively used alcoholic drinks using her Betty Boo's alcohol product such as While You Wait and It Ends With Buzz at promotional events. The public backlash was immediate and unforgiving. Given the circumstances and Lively's affirmatively hostile conduct, the Wayfarer parties were understandably concerned about a potential onslaught of negative publicity from Lively. On July 25th, 2024, the Wayfarer parties contacted crisis communication specialist Melissa Nathan and her company, TAG, to defuse and defend against Lively's anticipated assault and protect the film and Baldoni's professional reputation as a producer and director. The Wayfarer defendants also retained Jed Wallace to provide digital monitoring services. On August 2nd, 2024, the Crisis Management Public Relations team circulated a scenario planning document with a proposed strategy to counter against negative press and Lively's efforts to disparage Baldoni and Heath as the film's director and producer, respectively, tamp down the growing chatter on the internet's rumour mill, and handle the response should Lively and her team make her grievances public. Lively defines this defensive measure as the launch of a retaliatory smear campaign and contends that in the weeks and months that followed, the Wayfarer parties engaged in a sophisticated, coordinated, and well-financed retaliation plan. In fact, the Wayfarer defendants did nothing other than exercise their right to defend against Lively's attacks and the tidal wave of negative publicity triggered by Lively's conduct. Lively implicitly concedes that the goal of the Wayfarer Party's public relations effort was not retaliation for some protected activity, but to defend Baldoni and his reputation. The strategy described in the scenario planning document was never implemented because anti-Lively, pro-Baldoni sentiment went viral organically, obviating any need to take measures to control the narrative. The negative publicity spiked on the eve of the August 6th premiere and August 9th, 2024 release date. Lively's own timeline indicates that defendants could not have been the masterminds behind the spike in negative publicity. Lively points to spikes in negative internet traffic on August 8th and 14th, 2024. Wallace was recommended to defendants on August 7th, redacted. The first spike in negative digital coverage began on August 8th, before Wallace, the alleged digital wizard, was retained, and only one day after he was referred by Nathan. Even looking at the August 14th spike, Lively does not offer any explanation about how the tag Nathan, Abel, and Wallace were able to turn the entire internet against Lively in less than 2 days. These facts undermine Lively's presumption that defendants manipulated the spike in the already burgeoning negative sentiment targeted at Lively. Okay. The use of Signal by some defendants. After the crisis management team was brought on board in August 2024 and prior to Lively's filing of her claim on December 20th, 2024, certain defendants used Signal chats to communicate. Signal is a commonly used app which provides enhanced security features. The security protection Signal provides made Signal the preferred and primary means of communication between Nathan, the crisis manager, and Wallace, who operate in a highly charged media environment. Other defendants use Signal on limited occasions. Jamie Heath communicated at least twice on Signal during this period. Sarowitz, Baldoni, and Abel did not use Signal at all during the pre-litigation period to communicate about Lively. However, to the extent Signal was used, the participants had Signal set on its auto-delete feature. Defendants therefore have no Signal communications from the pre-litigation period. However, defendants also use traditional platforms such as text messages to communicate. Abel has produced these communications. As noted, Jones already had possession of all Abel's texts and emails prior to August 23rd, 2024, which had been downloaded from Abel's confiscated phone. Okay. The interlocking lawsuits. Lively filed her CRD complaint on December 20th, 2024, and on the same day sent a cease and desist letter advising the parties of a litigation hold. Brian Friedman, although he had been introduced to defendants in August 2024, was not retained until December 24th, 2024. If you remember, that's when Stephanie Jones filed her lawsuit in the Supreme Court against Jen Abel and Wayfarer. An engagement letter cautioned defendants to preserve documents. Shortly thereafter, defendants switched off the auto-delete feature. Non-privileged signal communications after December 20th, 2024 have been produced. So now this is where we separate away, because most of that was almost identical to Lively. So here now we are separating away, and this becomes Abel's opposition to Jones. Abel's third-party complaint against Jones for indemnification. In this action, the Abel action, Abel is seeking statutory and common law indemnification and contribution from her former employer, Jones, for liability arising from the Lively's action. There's a few typos in this I don't love, but Jones's defense is that in planning a public relations strategy for Wayfarer, Jones's client, between August 2nd, 2024 and her departure from Jonesworks on August 23rd, 2023. That should be 2024. Abel was a rogue employee acting outside the scope of her employment without Jones's knowledge or consent. Jones's complaint against Wayfarer and Abel for breach of contract and defamation. In a complaint captioned Stephanie Jones against Jennifer Abel, the Jones action, Jones asserts claims against Abel for breach of Abel's employment contract and breach of fiduciary duty by allegedly using and disclosing confidential information, which is rich from Stephanie Jones, and poaching Jones's clients and employees for her own business. Jones also alleges that Abel tortuously interfered with Jones's contract with Wayfarer, and Abel defamed Jones with statements that placed Jones in a false light. Although this motion is brought in Abel's indemnification action only, Abel anticipates that Jones will argue that the adverse inference and preclusion order apply equally in the Jones action. Okay. Jones fails to meet her burden to show that she is entitled to sanctions under Rule 37E1. So, and as I said, I'm not going to go over what the standard is. We've already covered that. So I'm just going to go to where they're applying it to this case. Okay. More severe sanctions, including an adverse inference presumption and terminating sanctions, are available only under Rule 37E2, which requires an additional showing that the spoliating party deleted or destroyed evidence with the intent to deprive the non-spoliating party of its use in the litigation. As noted, Jones is seeking draconian sanctions available only under Rule 37E2, including an adverse inference that the destroyed signal messages would have been favourable to Jonesworks and unfavourable to Abel, and demonstrated that the defendants, including Abel, conducted the smear campaign without Jones's or Jonesworks' knowledge, involvement, or approval, and that Abel's participation in that campaign while a Jonesworks employee, A, was for her own personal benefit, B, was not in furtherance of and was outside the course and scope of her employment, and not in discharge of her duties, and C, was not at Jones's or Jonesworks' direction. 2. Preclusion of Abel from arguing otherwise. Imposition of such sanctions would be tantamount to a dispositive ruling on plaintiffs' retaliation and defamation claims. Jones fails to show that Abel had a duty to preserve evidence. To even establish that Rule 37E applies, a party seeking spoliation sanctions must show that the destroying party had an obligation to preserve the evidence at the time it was destroyed. So, and then I'm going to go past that and try and get to the point where it applies to here. Right. Here, although Abel is nominally a plaintiff, her indemnification claims accrued only after Lively filed suit against her. In other words, in contrast to a typical plaintiff, Abel did not control the timing of the litigation in which she seeks indemnity. Nevertheless, Jones asserts that by early August 2024, litigation was not only foreseeable, it was actively contemplated. Lively, however, has two categories of claims. One, claims arising from sexual harassment or other mistreatment on set during Phase 1 shooting between May and June 2023. And two, claims of alleged reputational and other harm stemming from the alleged manipulation of the internet beginning in August 2024. Jones states that when Abel downloaded Signal for this matter in August 2024, she was on notice of potential litigation relating to the film and to Baldoni's and Heath's harassment of Lively on set. As evidence that Abel contemplated litigation in August 2024, Jones points to 1. The November 9, 2023 letter from Lively's lawyer, Leslie Strasberg, demanding certain protections on the set as a condition for Lively's completion of the film, which Heath sent to Abel as Wayfair's public relations agent on November 10, 2023. But why would Abel assume that she's going to be sued from that? And 2, Abel's admission that she suspected the possibility of litigation relating to the shooting of the film in or around mid-August 2024. Jones explicitly states defendant used Signal to coordinate the retaliatory digital campaign, communicate with journalists, and align with legal counsel on the narrative they would present to the press. Conversations focused on a response to the August 2024 explosion of media coverage triggered by Lively's hijacking of the production, exclusion of Baldoni from the film's marketing and premiere, and the very public unfollowing on social media. Thus, while Abel may have anticipated litigation relating to Lively's allegations of harassment during shooting of the film in May and June 2023, Jones presents no evidence, indeed does not even argue, that Abel or any other defendant anticipated litigation over their August 2024 public relations activities. Naturally, Jones would have a very difficult time explaining how Abel could have reasonably foreseen litigation in November 2023 over a retaliatory smear campaign that did not happen until August 2024. Hence, Jones fails to make the critical showing that Abel or any defendant could reasonably foresee litigation over a public relations strategy, or that their August 2024 messages were relevant to anticipated litigation that might give rise to a duty to preserve such evidence prior to the filing of Lively's December 20th, 2024 complaint. Absent a showing that Abel could have reasonably foreseen litigation arising from her August 2024 public relations work, Jones fails to show that Abel deleted Signal messages with a culpable state of mind, assuming she deleted anything at all. Moreover, Signal's auto-delete feature was disabled after litigation commenced, and defendants have produced post-filing Signal messages. Facts that weigh against the notion Abel acted with culpable intent to delete relevant evidence. Jones fails to establish that Abel deleted relevant evidence to Jones's prejudice. Rule 37E requires a showing that evidence existed and was destroyed. Jones does not show that Abel used Signal prior to December 20th, 2024 to communicate about Lively. Deposition testimony establishes only that prior to Lively's filing of her complaint, Abel used Signal to communicate with or about another very high-profile client unrelated to this action, and that although Abel activated Signal in August 2024, she does not recall using it to communicate about Lively. As noted, Jones fails to identify a single item or even type of relevant evidence that was destroyed by Abel or any defendant. Jones similarly fails to establish that even that Abel operated on Signal in connection with Lively. Jones does not cite any evidence establishing that Abel used Signal to communicate about Lively between August 2024 and the disabling of the auto-delete feature on defendants' phones after the filing of Lively's complaint. Although Abel activated Signal in August 2024, she does not believe that there were any communications on that Signal thread until December of 2024, when Lively filed her complaint. Abel does not recall whether she sent any Signal message at all in August of 2024, when the digital campaign was allegedly conceived and executed. Jones merely avers that from August 2024, the defendants operated on Signal. Jones defines defendants to include not only Abel, but Wayfarer, Baldoni, Heath, Sarowitz, Nathan, Tagg, Wallace, and Street Relations. As noted above, Rule 37E sanctions are personal, and the destruction of documents by one party cannot give rise to a spoliation sanction against another party. Therefore, Jones cannot and does not cite information relating to the alleged digital campaign that Abel could have deleted. Jones acknowledges these shortcomings by asking the court to simply presume that Abel had and deleted relevant messages that might have shown Jones's lack of involvement. Non-existent messages cannot be either relevant or prejudicial showings crucial to a Rule 37E spoliation analysis. Nevertheless, and without any evidentiary or factual support, Jones contends that, assuming they existed, that Abel's alleged deleted Signal messages would confirm Jones's exclusion, and that Abel's participation in the retaliation campaign was without Jones's knowledge and against her recommendations. And there is no question that Abel's Signal messages with the other defendants during this period would have shown that Abel's participation in the digital campaign was not at Jones's direction and that Jones was not involved. This can be inferred from Abel's recommendation of Nathan to spearhead this covert campaign over Jones's express objections and exclusion of Jones from that process from the subsequent work that followed. And Abel's destruction of that evidence has limited the universe of documents available for Jonesworks to use in this litigation to Jonesworks' detriment. This is pure conjecture and speculation. An assumption or speculation that allegedly deleted relevant evidence existed is not sufficient. Okay. Skipping over the citations. Jones contends that Abel may have deleted messages that may have shown that Jones was excluded from and did not direct the public relations strategy developed by Abel and others in August 2024, and thus that Abel was acting outside the scope of her employment. However, Jones does not dispute that at the time, Wayfarer was a Jones client, or that Abel was the Jonesworks employee responsible for the account. Jones also fails to mention that other text and email messages that were produced plainly show Jones's involvement in the lively Baldoni brawl, and that, as she alleges, Jones recommended against hiring crisis management specialist Melissa Nathan. Okay. Finally, even assuming Wayfarer engaged Nathan despite Jones's recommendation, Jones does not explain how this is evidence relevant to Jones's claim that Abel is not entitled to indemnification because she, rather than Jones, took the lead in working with their client. Nor does Jones describe additional evidence that might add to the evidence she already has. There is none. Hence, nothing that Abel could have deleted would affect or prejudice Jones's ability to prove that Jones recommended against hiring Nathan, from which Jones claims her non-involvement can't be inferred. Implicitly recognizing the fatal shortcomings in her argument, Jones urges that relevance and prejudice may be presumed, and the court may infer that deleted evidence was unfavorable where the spoliating party acted in bad faith or in a grossly negligent manner. As noted, Jones fails to show that Abel anticipated litigation in which communications relating to a public relations strategy might be relevant, and thus fails to show that Abel acted with a culpable state of mind. This failure to make this showing precludes Jones from making the higher showing of bad faith. The authority cited by Jones does not advance her cause. To start, Jones cites authority for the proposition that relevance and prejudice can be presumed for grossly negligent conduct has been abrogated. I'm going past the citations. Right, here we go. Jones does not establish the intent to deprive required for the court to presume relevant evidence unfavorable to Abel was deliberately deleted by Abel in bad faith after she was on notice of potential litigation relating to her August 2024 public relations work for a Jonesworks client. In any event, the cases Jones relies upon are inapposite. Okay. In contrast to Otterson and Arista, Abel was not a plaintiff who alerted Jones to the possibility of litigation and is not alleged to have deleted relevant information after the commencement of litigation. Nor, as explained in Section 3A above, could Abel have foreseen litigation over her public relations work in August 2024. Moreover, unlike Otterson and Arista, Jones does not identify specific evidence that Abel may have deleted. Jones thus fails to establish her right to sanctions under Rule 37E1, which are limited to those sufficient to cure the prejudice she has not shown. But Jones does not seek sanctions under subsection 1, where she seeks the more severe sanctions of an adverse inference and preclusion available only under Rule 37E2. Jones, however, fails to establish that any defendant acted with the intent to deprive her of specific evidence for use in this litigation, a predicate for the onerous sanctions available under subsection 2 only. Jones fails to meet her burden under Rule 37E2 for the severe sanctions she seeks. The more severe sanctions available only under Rule 37E2 require a showing that the spoliating party intended to deprive the moving party of information for use in the litigation. Okay. Legal standard again. We did all this and we went through all this in Lively. It's the exact same standards. Jones fails to meet any prong of the intent to deprive test. In fact, Jones does not acknowledge the intent to deprive requirement for the sanctions she seeks. Jones merely asserts in the most conclusory fashion that Abel's intentional use of signal and failure to disable auto-delete suffices to infer intent to spoliate. Intent to spoliate is not the standard for an adverse inference or preclusion. Rather, a party seeking sanctions must show an intent to deprive Jones of evidence for use in this litigation. Nor does Jones describe facts that would meet any prong of the intent to deprive test. First, as shown in Section 3b above, Jones fails to show that relevant evidence once existed that could fairly be supposed to have been material to her defense of Abel's indemnification claim. At issue are signal chats between the public relations crisis management team and/or Wayfarer defendants in the pre-litigation period. August 2024 to December 20th, 2024, plaintiff only speculates that the deleted chats may reflect that Abel excluded Jones from the communications and work being performed on behalf of a Jones client. Second, plaintiff does not show that defendants acted affirmatively to cause relevant evidence to be lost. Third, addressed in Section 3a above, Jones fails to show that Abel deleted any relevant signal messages after litigation commenced or that she was on notice of potential litigation over her August 2024 public relations activities, which are the subject of allegedly deleted messages and the only topic relevant to Abel's indemnification claim against Jones. Finally, the use of signal by the public relations crisis management team can be credibly explained. At the time the crisis management strategy was developed, the internet was already ablaze with stories about the Baldoni-Lively dispute, triggered primarily by Lively's conduct in excluding Baldoni from the marketing of the film and the premiere, Lively's unfollowing of Baldoni on social media, and Lively's own missteps in marketing the film. And I will say, we did see in the motion for summary judgment, there are text messages between either one of the Wayfarers or Jan Abel. I want to say it's one of the Wayfarers, possibly Jamie Heath or Justin, where Stephanie Jones was texting one of them, and they were, sort of complaining about the negative press that Lively was putting out. And Stephanie Jones acknowledged that and said, and I'm kind of quoting, paraphrasing here, that it's not surprising. It's something like that. It's disappointing, but it's not surprising. It was a bit of a catty swipe at Lively, but Jones acknowledged the negative press that was being put out against Wayfarer by Lively. So she was involved. She was aware. Okay. Surely even Jones would admit that keeping crisis management communications confidential and safe from hackers and aggressive media players can be credibly explained as not involving bad faith by the reason proffered by the spoliator. For the foregoing reasons, Abel respectfully requests that the court enter an order denying Jones's motion for Rule 37E sanctions in its entirety. Okay, so that is the Abel response to the Jonesworks even more ludicrous request for these spoliation sanctions. To quote Ellen Garofalo, it's this. The request is odd. This was a good document in terms of the arguments were incredibly good and the sass was good. If I had to sort of be picky and say, is there something I didn't like about it? And compared to the Lively, there was a lot more typos and sort of spelling and grammar errors, which, like one or two, they're not liked at all. Even one is not liked because, the position even of a comma can change the meaning of something. But there was, quite a lot here. And it looked a bit rushed. And it probably was, to be honest, because this is the second filing of pretty much the same motion. So, and they've had to combat a lot of things recently. They had the motion for summary judgment as well, and big filings and lots of nitpicky whiny little ones from Lively in particular, that Wayfarer have had to deal with. And Wayfarer, their lawyers they're decent, they're really good firms, they're quite big firms, but they are not the huge global size. And that's why I think in part, as well as for the specialism, they've taken on, I think there's now actually 4 law firms, because you've got Mitra Ahurian's firm as well. Like, she has her own firm. You've got Meester, which is Kevin Fritz's firm. You've got Friedman's firm. And now we've got Shapiro's firm. So, got all those lawyers. And there are multiple parties as well, multiple defendants. So, yeah, I can understand it, but I just think that you could have spent a little bit more time just taking out the oddly placed "thes" and just sorting out some grammar as well. There's nothing in there that I think that overly changes anything. The only thing is putting down Jen Abel's date of termination as August 21st, 2023 instead of 2024. Even that really doesn't change much, because by now we are all very much aware, as is the court and all the parties involved, of when Jen Abel was terminated. But in other kind of scenarios, that could have given a different picture. So that's just my thoughts. Anyway, it was a very good document. Both of them were very good and great arguments. So now we await Lively and Jonesworks' response. Okay, so that's me for now. I'll be back if there's something comes down on the docket later. Take care.